All right. Good evening, everyone. Thank you for joining us for the Physician Immigration Update in 2025 with Elissa Taub. I'm going to give everyone some time to get logged in. In the meantime, though, I'll go ahead and introduce myself. My name is Rainey McNeely. I'm the Physician Engagement Specialist here at Practice Match. Some of you might know me from attending our live career fairs recently, or if you've submitted your CV for review. It's my job to connect with training residents and fellows and share some information on all the free career resources we offer. Practice Match offers free CV builder and review. We have a physician guidebook, an immigration handbook, which Elissa co authored. We've got a free job board, scholarship opportunities, and more. You can find a full list of our resources at our website, practicematch.com. I do want to make a note that tonight's webinar is being recorded, so the microphones will be muted. If you have any questions on what Practice Match can offer you, please feel free to just reach out to me. But if you have questions tonight during the webinar, please make sure to use your Q&A box or the chat box, and they'll be answered throughout the presentation. Again, this webinar is being recorded, so your microphones will be muted. Make sure to use that Q&A chat box if you have questions. Let's see. We'll wait a couple minutes. It looks like we do have some people logging on. Elissa, if you're ready, you can take it away.
Great. Thanks so much, Rainey. It's great to be here with you all on this lovely Thursday evening. I hope you are all having a great day. As we get started, as Rainey said, I'm an immigration attorney. I'm a partner with the law firm Siskind. My practice primarily consists of physician immigration. I head up our firm's healthcare immigration group, and I work a lot with physicians and then also with other folks on healthcare, nurses, PTs, you name it. If it's a healthcare worker position, we're going to work on that petition. But really, the heart of my practice and what I've spent most of the last 18 years doing is working with physicians and their employers to navigate the immigration process. Tonight, we're going to go over some hot topics. As I was preparing the slides, I usually do like one quick slide on hot topics, and then we talk about like physician stuff. And as I was going through the hot topics, I realized it could be the whole webinar. And so we're going to talk about some things that maybe, are related to physician immigration, but might not be the specific usual content that we would cover when we talk about doctors. I do have some really important information to share, and I will give some like J1 waiver updates and things like that at the end of the presentation. Before I get into the substance, though, I do have a couple of housekeeping things I want to mention. The first thing is, unless I'm already your lawyer, this webinar does not make me your lawyer. So we are not intending to create any attorney-client relationship between myself and those of you who are watching. And also, because this is not a confidential setting, I can't answer like specific personal immigration issues in this setting. It really wouldn't be appropriate. I am, though, happy to answer your questions as they come up. If you do have more specific things that you want to discuss on a one-on-one basis, I will share my contact information at the end of the webinar. There are ways to go online and schedule a consultation. And if you're not sure if I'm the right attorney for that consultation, I could always point you to the right person in our office who might be able to work with you. All of that said, let's dive in. So there we go. So this is just an overview of what we're going to cover during the presentation tonight. Really starting at the beginning of the year so far, talking about a lot of the immigration updates that have happened so far this year, giving you an idea of where we think things might be headed, and a little bit of advice to kind of navigate the period of uncertainty, chaos, upheaval, whatever we want to call it, that we're in right now. And then, of course, at the end, I'm saving the good news to the end. I'm sorry, guys. You've got to sit through all of the craziness to get to the positive news, but there is some positive news, and so we'll talk a little bit about that as we finish up. So to get us started, I'm going to go to the next slide, and we're going to talk about the thing that's really one of the biggest things that we've seen so far since January. There were a slew of executive orders that were signed on January 20th. And during that first week of this new administration, and we've had some other executive orders that have also been signed along the way, some as frequently as just in the last few weeks or last month. I'm not going to go step by step or order by order and say this one did this and this one did that. I think what we need to know, and I think what most of you need to be aware of, is what the effect of these executive orders are. Executive orders are not laws. The president actually, I know it's shocking, but the president of the United States does not have the ability to make law. What he can do, though, is make policy. He can set priorities for his administration, things that he wants to accomplish, and then he can use executive orders to say what those policy goals are and to instruct the different agencies of his government to implement those policies. So that's what these executive orders have done. Now, just because the president puts it in an executive order doesn't mean it's legal, doesn't mean it's constitutional, and doesn't mean it happens right away. So, for example, one of the first executive orders that the president signed on day one was an order that purported to end birthright citizenship in the United States. Right now, as many of you know, you're born in the US, you are automatically a US citizen. The president wants to end that longstanding tradition. And under the law, he really doesn't have the power to do that. I think most reputable attorneys and scholars who have looked at this issue don't even think there's an issue, right? It's just very clear what the law is. So far, there have been 4 or 5 lawsuits filed around the country challenging that executive order. They've all ended up in an injunction of one sort or another. So that executive order has not taken effect. The administration went to the Supreme Court and asked the Supreme Court to say, oh, you know what, you can't have a nationwide injunction on this. I don't think that will be successful because that would lead to different rules in different states, which is really not, that's not how US immigration works. So bottom line is, just like with everything else, just because the president said it in an executive order, it doesn't mean it's actually going to happen. There are a few other executive orders, though, that are a little bit more concerning and may have a little bit more impact on how you and how other physicians navigate the immigration process in the United States. One is that they announced a federal hiring freeze. And what the hiring freeze says is that, A, the federal government can't hire any new workers. And even if somebody leaves and they have an important position, they can't be replaced unless it's something like a matter of national security or something like that. Few of the upshots of the hiring freeze is that, for example, if consular officers leave the Foreign Service and they leave the Department of State can't replace them, which could lead to lengthier processing times when you apply for a visa if there aren't enough consular officers to handle the applications. The Department of State already has, a shortage of consular officers. So that's one thing we're worried about. We're also a little bit concerned about some of the federal J-1 waiver programs, about whether the people who administer those will stay in their positions long term. So far, we have not seen any substantive changes to the way those programs are being handled. Oops, I just gave away some of our positive news. But in general, if people leave the government, their functions are, potentially going to have to be assumed by other people who may end up being really overworked, or we might see those functions subside. Like I said, so far, we haven't really seen that come to fruition, but it's a concern, right? Because there's a federal hiring freeze and it's not likely to be lifted. If you've been following the news and what DOJ is doing, they're basically trying to gut the entire federal government. So HHS, for example, Health and Human Services has already lost 10,000 employees. Now they want to cut 10,000 more people. How that might impact waivers filed through HHS is anybody's guess at this point, or whether it will affect those, right? We don't know exactly the positions that are being eliminated, but that's a stay tuned. It gives you an idea of how a federal hiring freeze could impact immigration applications. Note that it likely won't impact USCIS. USCIS was not subject to those DOJ buyouts for the most part, and because it's a fee-funded agency, they're a little bit on the periphery. And also the Department of USCIS and the Department of State's National Visa Center, they use a lot of contractors as well. And those contracts were already in existence at the time the hiring freeze was issued. So there's also some safety there that they're not going to just fire all those folks. So for now, those agencies seem to be in the clear. Oops, go back one. No. Okay. Back to executive orders. We have also had some national security and border security executive orders. And, for those, you can expect to see an increased incidence of quote unquote extreme vetting. So this may manifest itself in more frequency of administrative processing and delays in getting visas issued. We also might see on the USCIS side an increased number of green card interviews. We've been hearing, during the last Trump administration, every person who applied for a green card under any basis had to go for a USCIS interview. Under the Biden administration, almost nobody did. They were mainly just doing naturalization interviews. Now we're in the process of morphing back to an everybody gets interviewed situation. We're not there yet. It hasn't been fully implemented. Clients of mine are still getting green cards without interview, but we're going to see an uptick in the interview side of things as part of this extreme vetting. That's also going to cause eventually the processing times for green cards to go back up again. And then finally, just recently, there was an executive order on fighting anti-Semitism. And one of the things that we're seeing, and one of the things that executive order sought to do, was to direct the Department of State to look into people on student visas and other statuses who might have been part of the campus protests at places like Columbia University and stuff last year. Without getting into what the substance of those protests or anything like that, this is a really big deal. And I'm going to get into a little bit more about that on the next slide when we talk more about consular processing updates and exactly what the impact of like visa revocations should be. It's very clear to me that a lot of the folks that are working in the federal government right now who have responsibility for immigration as part of their portfolio don't necessarily know how U.S. immigration rules operate. That's not stopping them from creating rules and trying to implement a whole new regime, but the laws already exist and there are ways that things are supposed to operate, and they clearly are mischaracterizing a lot of that. So going on so that gives you a little bit of a background on what's going on, from the executive order side of things. And like I said, we're not going to do a deep dive. We could be here for an hour parsing the language of every executive order. But just to give you an idea of the things, the executive order is issued. Well, the executive order doesn't say, do green card interviews, right? But when USCIS goes to implement that executive order and they're told they need to vet people more closely, one of the things they will do is more interviews, right? So that's sort of how that regime works. Okay. More specifically, let's talk about, we're going to spend a little bit of time now talking about consular processing and travel. The next slide is all about travel. We'll get to that in a minute. I know my email inbox has been flooded over the last few weeks with questions about travel because there have been well-documented and reported stories. We will get to that on the next slide. What I want to talk about now is an offshoot of what we started to talk about with these executive orders, which is potential delays and heightened scrutiny when individuals apply for visas at U.S. embassies or consulates abroad. As we talked about with the last slide, if consular officers leave their posts or are dismissed, the federal hiring freeze prevents them from being replaced. That is going to be one source of increasing delays. There has also been a change in who qualifies for an interview waiver when they apply for a visa. Many of you know interview waiver by its other name, the drop box. Since COVID, basically, or since the early days of COVID, a lot of folks who normally would have had to go for an interview at the window at a U.S. embassy or consulate could bypass that. And instead, you'd either drop off or mail in your documents once you got abroad so that your visa could be processed without you actually having to appear for an interview at the embassy. And the government had kind of broadened that interview waiver so that you could have had a visa that expired up to 4 years ago, and in a lot of cases still been able to bypass your interview. In the beginning of February, that all changed. Right now, the only way you get to use the Dropbox or bypass the interview when you apply for a visa is if your last visa in that same category expired less than a year ago, right? So we're talking about you're in H-1B status now, your last visa stamp that you got abroad was also an H-1B visa, and it expired within a year from when you make the new application. We're not talking about your status, we're talking about the actual visa stamp in your passport. So same category, the visa had to have expired within the year before you apply for the new one, and you have to apply in your home country. So those are really important things, right? You can't, if you're from India, you can't go to Canada and qualify for interview waiver. If you're from, France, you can't go to England and qualify for interview waiver. You can only apply in your home country to take advantage of that. And you can't have anything that makes you inadmissible or any prior denials of visas that weren't otherwise overcome. So if you're going to need to apply for like a 212D3 waiver because you have some prior criminal issue or some other inadmissibility, you're going to have to go for an interview. They're not going to allow you to bypass the interview requirement. So those are the new interview waiver requirements. So one of the things that this is going to do, in addition to being, kind of a pain, right? And disruptive to your travel, it also means that more and more people need to schedule consular interviews, which means that the wait times to get an interview, could grow longer. One of the things that the State Department did almost on day one was they took down the visa wait times page from the travel.state.gov website. The visa wait times page, many of you might be familiar with it. It was the place that you would go and you say, oh, I need to go apply for a visa in Kingston, Jamaica. I wonder how long it's going to take me to get an appointment there and how long it's going to take me to get my passport back after I submit my application. And you could go on and it would tell you, it would give you the wait times for pretty much any embassy in the world. And they weren't always super accurate, but you gave you some ballpark. They took down that site almost immediately. They replaced it with a more static global visa wait times page that last was updated on January 7th. So we are not getting any real clear information about global visa wait times at this point. So the only way you're really going to know how long it's going to take you to get that appointment is to log into the system, submit your application and look for an appointment. It's very, very frustrating. I know that there are folks out there trying to approximate or find that information, but right now there's no real official source for visa wait times available online. On this next note about FMJ students maybe receiving more scrutiny, that's where the anti-Semitism executive order comes into play. And don't be alarmed maybe don't be alarmed with the inclusion of J visas there. I've read the cable that Secretary Rubio sent to all consular posts recently, instructing them to apply this anti-Semitism executive order broadly in denying visas to people wanting to come to the United States as students based on potential political activity that they've undertaken. It does specifically in the J category mention J1 students and scholars. It does not specifically mention any other J1 categories like au pairs or physicians or other folks that have interns and trainees and folks like that who come in other J categories. It still, to me, makes some sense if you're, traveling home to apply for a J1 visa stamp in your passport to be very aware of this executive order and to look up some of the news reports about the cable that Secretary Rubio sent to the consular post about extra vetting for FM and J students in light of the anti-Semitism executive order. It is very broadly written. And in fact, Secretary Rubio gave some comments today, which make it clear that activities that typically would be covered by the First Amendment, writing op-eds, expressing yourself online, going to a protest where you're not engaged in any kind of violence or obstruction, activities where you are not breaking any other law, that this administration has decided that issuance of visas is a foreign affairs activity that they have unlimited discretion to undertake, and that if somebody expresses an opinion that is not in line with the foreign policy of the United States, that they have the authorization to just outright deny a visa, and that they may even look at terrorism grounds for that denial, which would make it very difficult to obtain any other visa to the United States in the future. So I cannot say this strongly enough. Regardless of anything, it is critically important that if you are traveling and you are seeking, any kind of visa, not just FM or J, although the guidance was specifically with regard to students, but even with H-1Bs, with Os, other visa categories, it is critically important to look at your online profile, determine if there's anything in your text messages, your social media posts, anything like that, that under these guidelines, the government might find objectionable. I cannot define for you exactly what might be objectionable. And I cannot give you in this forum specific advice about what to do and not to do. We'll talk a little bit more about travel issues on the next slide. But it is critically important because this administration is taking a very broad view for what support for terrorism might be. And I think it's very troubling. I think there are definite First Amendment implications and issues here. And this is a very different approach than the US government has ever taken in the past, even in the wake of 9/11, when we did see a lot more restrictions. So it is critically important to be aware of these developments. The other thing I wanted to mention here, in addition to that, sorry to be so doom and gloom, I don't have a choice. The other thing is to understand, I know, with some of the news reports on folks being detained or denied entry into the United States, and the news makes a really big deal where they had a valid visa. They just got a visa stamp. They were coming here with a visa. It's important to understand what all the different agencies involved in U.S. immigration do. There are multiple layers of federal agencies that manage and handle the immigration functions for the U.S. government. So I'll give you an example. Let's say you find a job and you have an employer who sponsors you for H-1B status, and you're already here in the US. Maybe you've gotten a J-1 waiver. Maybe you've always had an H-1B, and they're changing your employment so that you can now work for them, right? So there's some H-1B petition being filed for you, and that petition is going to be filed with USCIS, the U.S. Citizenship and Immigration Services. They handle all immigration petitions, basically. Applications for people to change or extend stays from inside the United States, green card applications that are filed from inside the United States are all adjudicated at USCIS. So you'll get your H-1B approval from USCIS. Maybe it extends your stay for a little while longer in the US. And while you have that H-1B approval, you decide to travel home to visit your family. Very typical thing to do. But you need to get a new visa in your passport because the approval notice from USCIS, unless you're a Canadian citizen, that approval notice does not allow you to re-enter the US, right? It allowed you to stay here if you were already here, but it doesn't allow you to come here. And if your H-1B was approved while you were abroad and you've never been to the US, well, that approval notice also doesn't allow you to stay here or to come here. You need a visa stamped in your passport in order to be able to come to the US border. The visa is like a ticket of admission, right? It's like, okay, the State Department found that I'm not inadmissible to the United States and I'm qualified and otherwise, everything looks legit with my petition. So that's the agency that is going to administer the visa. You make an appointment at a US consulate or embassy in your home country. And the State Department manages all those consular posts, and that's the agency that's going to review your visa application and issue you the visa. And that seems like it would be the end of the story, right? You then come to the border with your valid visa stamp, and you're like, here I am, I've got my approval notice, I've got my visa, everything is going well. And then you run into an officer from Customs and Border Protection, CBP. And they do the analysis at the border of whether somebody should actually be allowed to step foot in the United States. And the thing about CBP is that they're kind of like a law enforcement agency. And so they have a little bit more discretion, a little bit more authority to review you and whether you might pose a threat to the United States upon entry. And they also will assess whether they think the purpose for your travel to the United States is in keeping with what your visa allows you to do. So you come to the border and you see CBP And they decide, no, I think there's something suspicious about you. And they pull you into secondary inspection for some additional questioning or whatever, and they can decide not to allow you into the United States. We'll talk a little bit more about how that analysis at the border works on the next slide. But it's important to know, so we've just discussed three different government agencies that can, that have a role to play before you even get to the States. Or if you're already here, that can apply if you decide to travel, right? So we've USCIS, the State Department, and CBP. And then, if you're going to be removed from the United States, then ICE would actually get involved, Immigration and Customs Enforcement. We hope we never see them. ICE is the CVIS system that governs your J1 status or that governs F status, actually is maintained and managed by ICE. So that's, if you've been on a J1 in the US, you have interacted with ICE already, just not in the way that people normally would expect. So there's our, some consular updates for you. One of the challenges is that individual consular posts can sometimes make their own policies, right? So when we first heard about the changes to interview waiver, we were getting reports out of India before anywhere else. And then we started getting reports out of Paris. And then like the next day, the policy was announced. So sometimes we, can see some of these things creep up. And right now there's a lot of upheaval in the computer systems, the software that we use to schedule appointments and make those applications. So there's a lot of flux and a lot of stuff going on with the consular system to be aware of. The other thing I'll mention just real quick before we go to the next slide is that if you are going to apply for a visa, I would very strongly recommend that you contact, if you're, on a J, if you're in residency or fellowship now, I would very strongly recommend that you let your program director and or your GME office know in advance that you are traveling abroad, where you're going, and that you're going to be applying for a visa stamp while you're there, and that there is a possibility you could be delayed in your return. They need to know that before you go. Same thing if you're an attending physician, let your employer know what your plans are. I know that feels very, kind of big brotherish, like why do I have to tell my employer all of this? But if you're an attending physician and your employer is going to need to line up locum coverage or some kind of emergency coverage for you if you're delayed, it is way better if they have a sense that they might need to do that in advance so they can at least have people temporarily committed rather than needing to, maybe find coverage with less than 24 hours notice. So I've talked to a lot of employers. They've said yes, and GME folks who have said yes. We definitely want to hear from our residents, from our fellows. We definitely want to hear from our employees if they're traveling. It just goes a long way to be a good communicator and make sure that you're being upfront with the folks that this really affects on the back end as well. So just keep that in mind. All right, so let's go on to travel, because I know that's like a burning thing. You see how I saved it for the middle. So, all right. So there are a few things going on travel-wise over the last month. I'm sure all of you watching this have read the news, have talked to friends, have talked to colleagues, family members, and everybody is just freaking out. And there's a lot going on that's very troubling. The first thing I want to mention is that I have advised my clients, regardless of their countries, regardless of their status in the United States, with the small exception of green card holders, right, and US citizens. But my clients who are on visas, I don't care where they're from, even Canada, I have told everybody pretty much, I would prefer it if you did not leave the country over the next several weeks. We do expect that there's going to be some kind of travel restriction or travel ban announced imminently. Like, I'm not online right now, and I literally know it's going to be coming any day now. We thought we were going to have it last week. There have been some delays for some specific reasons. They're trying to hammer out some specific language in the ban. So I don't know exactly when it's coming, but it's coming. The fact that it hasn't been issued yet does not mean they dropped it. It's just a delay. You may have seen the New York Times reports about the travel ban that had the red, orange, and yellow countries, and you might notice that my slide has no colors other than blue and white. And the reason for that is that that New York Times report was based on a leak or information that they were provided by the State Department, who wrote the initial version of the ban. The State Department then gave that draft to the White House for further review. And as far as I understand, the White House is hammering out some different details. So I think the New York Times report is very instructive about how this thing might be structured, but I also think we can't make any specific conclusions until we actually see the text that is issued. And that includes the countries that are included, what the specific restrictions are, when it goes into effect, how long it's going to be in effect. And I also am concerned that there could be some broader travel restrictions announced in that document that may not be country specific, which is why I've just told everybody, look, I don't know all the countries that are going to be included. That New York Times list, was helpful. Is it final? No. Could the final list be the same? Sure. We just don't know. Could there be other parameters in what's issued that might apply to everybody, regardless of where they're from? Sure. Like, what are they? I don't know at this time. So it's really important. I would be as cautious as possible about making travel plans, now into April, maybe even into May. I think by the time we get to the summer, June, July, we will have a much clearer picture of what is going on. And how to navigate it a little bit better. But right now, man, there is a lot of chaos and a lot of upheaval in the world of travel. And my biggest fear is that one of my clients will choose to travel for whatever reason. It could be a great reason, right? Could decide to travel ban drops, and they get stuck abroad, and there's almost nothing we can do, right? And I just don't want that to happen. I want I want folks to be able to decide if they want to leave the US for good, and not be stuck into it, right? So that I could not feel more strongly about this. And I will tell you, I do not like giving this advice. This is only the second time in my career as an immigration lawyer that I've ever given this advice just across the board. And the other time was during COVID, when countries were shutting down their borders, and if people went home, they couldn't get out. Or if they they couldn't get in, and all of this, and it was just a mess. I hated it then. I hate it now. It is not lost on me as a natural born U.S. citizen that I can travel. So I don't like to tell people that they can't, but I feel strongly enough about it right now that I just think it's a bad idea. All of that said, if you need to travel, if you decide to travel, maybe you're not going to travel over the next month, the travel bans come out, you're in the clear, you're like, great, could finally go home and visit my family. There are still some things to think about. Some of the through lines, some of the commonalities in the cases that we're seeing reported in the media have to do with CBP pulling folks aside into secondary inspection when they come to the border and searching their electronic devices and finding material on those electronic devices that is in some way, shape, or form objectionable. The anti-Semitism executive order and the cable from Marco Rubio might give you an idea of some of the things that are being found objectionable. Those are not the only things. I won't go into all of the news reports here, but be very, very careful about what is in your phone, what is in your social media, what is in your WhatsApp, and Telegram groups and all of that. You may have a setting in those chat groups where if you click on a picture, it automatically downloads into your photo gallery. I would turn that off, because then you're saving any media, you're saving directly to your phone. It's not just living in that app. And that I've heard some reports of folks who didn't even know that those materials were still in their phone. They hadn't created those photos or whatever it was. They didn't intend to download them onto their phone, but they just clicked to open a picture in a giant Telegram group. And the next thing they knew, they weren't allowed into the United States because the CBP officers decided that they were terrorists. So be very, very careful. I'm going to run down just a few things about electronic device searches. There is a lot of information, a lot of material available online about this as well from the ACLU and from the American Immigration Lawyers Association. I'm actually there's a one pager that the Immigration Lawyers Association has put out that I've been sharing with a lot of my clients because I feel like it's very well done and easy to read. Um, One of the most important things is that if you are not a US citizen or green card holder, when you come to the border, the government does have the authority to request you to hand over your phone or other electronic devices and to unlock them, meaning give them the password or open the device for them. You don't have to share your password, but if you don't, they could actually just seize the device and hack into it. You could also be denied entry if you won't hand over the device. So that's important to know. US citizens, green card holders have a little more leeway. US citizens can refuse to answer questions. It might delay your entry into the United States. Same thing for green card holders. But for visa holders who refuse to answer certain questions at the border, they can just turn you right around. And right now, you know, in the olden days, before January, a lot of times, if it wasn't something criminal or something that would lead you to have a longer absence from the United States, they would just let you withdraw your admission, you know, withdraw your application of admission to the United States. They're not doing that now. They're just detaining people and then sending them home. So they're not letting you say, oh, you know what, my bad, I'm just going to go home. They're actually like putting people in immigrant detention and for a while, a couple weeks, just to scare them, and then eventually they send them home. So I would be very careful about your interactions at the border. In terms of the electronic devices that you bring with you, as I mentioned, I would be very careful about the apps that you have downloaded. You might want to put certain things in the cloud or just erase them entirely before you come to the States. You may want to use electronic devices that you obtain specifically for that trip and then wipe them before you come to the United States. There is a lot more in-depth advice in some of the materials, like I said, from AILA and the ACLU. I would highly recommend checking them out. I'm a few other things though, in terms of your interactions at the border. Know that you have no right to counsel when you are placed in secondary inspection or any time that you come to the US border. You're not on US territory yet, even though your plane has landed here. So if you get put into secondary detention and you say, I want my lawyer, they're going to say you can't have your lawyer. They do not allow us by telephone or in person to come into those into the secondary inspection area. You might want to make sure, though, that people that you're traveling with, if you're not traveling alone, you know, if you have a spouse with you or friends or whatever, that other people that are with you have your lawyer's phone number or email address so that they can reach out right away and let somebody know that you've been, you know, potentially detained, especially if you don't come out of secondary inspection, right? You know, and say, oh, wow, that was, you know, no big deal. And I should mention there are other reasons why people might go into secondary other than what we're talking about, right? If you're traveling using advanced parole, you probably get put in secondary as a matter of course while they confirm that everything is still valid, right? So there are other reasons that aren't scary that somebody might end up in secondary. I'm just here today talking about some of the stuff in the news that we've seen and some ways to avoid that and try to minimize your risk upon travel. Okay, so no right to counsel at the border, no right against unreasonable searches and seizures. So unless you're a US citizen or green card holder. And what that means is that, as I mentioned before, they can take your phone, they can take your other devices, they can look through your bags, they can pat you down. If they really think you have contraband, they could do a strip search. That's very unusual. Don't, you know, but like just, you know, think about there are extreme things that can happen if you don't have a right against an unreasonable search or seizure. So be aware of that. When you interact with CBP officers, be truthful, be calm. I think the worst thing you can do is, you know, really lose your temper because that's going to cause them to escalate as well. On the be truthful side of things, there's a gray area, or not gray area, there's a fine line between telling the officer that everything that ever happened to you in your life going back to when you were 3 years old and telling the truth in response to a question that they ask you, where are you going to be staying in the United States? Or what is the purpose of your trip? Say less, right? Keep your answers short to the point. What is the purpose of your trip to the United States? I am returning to resume my medical residency. Where are you doing your residency? I'm doing my residency at such and such a hospital. What field are you studying? Internal medicine. Great. You're done. You don't have to say, this is the fourth time I'm coming into the United States on J1 status. I'm really excited about that. And I got stuck in administrative processing before I got my visa. I was a little worried I wouldn't get here, but they finally gave me the visa. So now I'm here and it's been a really long trip and I'm really like, no, just I'm coming in to resume my medical residency, right? Like you can see that there's a difference between giving the person all of this other information that's absolutely 100% irrelevant to the question that they asked you. Be very, very limited in your responses, but be truthful, right? Don't be misleading. Don't be cute. Be truthful in your responses because one of the worst things that you can do with the border is be accused of misrepresenting yourself. So again, I said, it's a fine line between the two. And for every person, there's going to be there's a level of comfort with that, but be very careful with how you represent yourself at the border. I will also mention just, this is all very, these things can be very scary and can cause a lot of people to be, really nervous. Every day, like thousands upon thousands of people enter the United States uneventfully. One of the folks in my office, their parents visited from overseas last week, and we were all nervous. And they came in as visitors from their home country. They were accompanied by their son-in-law, who is a U.S. citizen, completely uneventful at the border. They came in on their valid B1, B2 visas, and everybody's here and happy. So for every report that you see in the media about bad stuff, there are a lot of people who are entering the United States uneventfully every single day. That doesn't mean we don't have to worry about this stuff, right? It doesn't mean that we should ignore all of this and say, oh, well, that's those people, right? Because there's a little bit of a sense of unpredictableness with all of this, unpredictability with all of this, it is important to be prepared. But I give you that as just a word of caution. Even amongst immigration lawyers, we're like, okay, are we overreacting when we tell people not to travel? And then we're like, okay, well, I don't necessarily want my clients to be on the 11 o'clock news because they're stuck at they got stuck at the border for some crazy reason. So proceed with caution and and hopefully all of this will die down as we start to learn more about what the government's really worried about. Okay, so that's my word about travel and consular processing. I see there are some questions in the chat, and I'm going to hold those to the end because they're not directly relevant to what we're covering right now, but I will answer them. Okay, so let's go on to the next thing real quick. The next few slides are going to be a lot faster than what I've already gone through. I want to just update that since the beginning of the year and even more recently, like even as recently as last week, the government has canceled some benefit programs that were existing both during and before the Biden administration. Significantly, the parole programs for people from Cuba, Honduras, Nicaragua, and Venezuela was announced to be suspended last week. The suspension takes effect, I believe, on April 24th. The Uniting for Ukraine and Afghan parole programs already have been suspended. So no new benefits can be approved under those programs. And notably, so all of the people who entered the United States under those programs did so legally, right? The government gave them a pathway to come here and said, you come here, and then if you want to stay, you got to figure that out, right? But we'll let you come for like 2 years or whatever it is. So a lot of people did that. They came to the United States on these parole programs, and then through family members or other means, they applied for green cards, or maybe they applied for a new status or whatever it was. And now USCIS has suspended benefit applications for all of those people. So if they have a green card application pending, it's in suspense. If they had some other application pending, the handling of it has been suspended because the government is taking the position that all of the people who entered on those programs basically entered the country illegally, which is not true. So that's a whole set of upheaval on that side of things. On the other side of things, for those of you who may have TPS, there have been Some developments with TPS for people from Venezuela and from Haiti. For Venezuela, they canceled the extension of TPS and have reverted back to the original designation in 2021. So Venezuela TPS expires now on April 7th. And for Haiti, they also canceled the extension that was announced, and now that expires on August 3rd of this year. I'm concerned, and many of us are concerned, that other countries that currently are designated for TPS will see those designations not be extended beyond their current termination dates, beyond the current expiration dates, which could be anywhere in the next year or two. It's really important, if you have TPS, not only to watch that news, but also to talk to your immigration lawyer who filed that TPS for you, because you may have other pathways, other options available to you besides just TPS. If you're in a residency program, they may be able to switch you to J or H status. If you're working as an attending physician, you may be eligible for an H or an O, or even to go directly to a green card, depending on the green card backlog. So, and how you entered and when you got TPS and all of that. There are a lot of questions there, right? So this is not the right setting for me to give you advice on that, but definitely talk to your lawyer about TPS, even if you're not from Venezuela or Haiti. It's really important to be prepared for the eventuality that this administration is just going to end it all at some point. So, end all TPS at some point. So, be prepared about that. On a different note, on March 12th, the government published a regulation re-upping and implementing a registration requirement. This registration requirement goes into effect on April 11th. It requires certain people who were in the United States who haven't previously registered to do so with the US government. Notably, if you entered the United States with a valid I-94, with a valid visa, and you were fingerprinted through any of that, you do not have to register. So most employment-based immigrants who are employment-based non-immigrants, folks who came on H's, J's, L's, O's, E's, all of that alphabet soup, the likelihood is you got a visa stamp in your home country, came to the United States, and you were issued an I-94. Even if you're Canadian, you probably got an I-94 at the border. It's available online, that shows that you entered the country legally in the status, and you likely do not have to register. But if you were Canadian and you weren't issued an I-94, either as a visitor or in your work authorized status, and you're here for more than 30 days, you'll need to register. And if you have children who were under the age of 14 when they legally entered the United States on H4 visas or whatever, in J2 visas, whatever it was, under the age of 14 when they legally entered, they will have to register when they turn 14. So those are two important groups of folks who do need to make sure they're paying attention in this registration stuff. The registration happens online. You have to create an account on USCIS's website. The form will be available in there for filing. I would recommend, if you think you are subject to the registration requirement, to consult with an immigration attorney about that. There are lots of questions. And I'm not thinking about the kids or or for the most part, the Canadians, although they may have some questions. I'm talking about everybody else, right? Folks who might be here who are undocumented, who might be subject to the requirement, or might be underdocumented, who might be subject to the requirement. Definitely recommend consulting with your immigration attorney about whether to register, how that works, and what the risks of registration might be. Under the law, you have to do it. And there could be criminal penalties for failure to register, or other penalties for failure to register. So it's really important to understand what those are, and especially if that applies to you. Okay, last bit of bad news, and then we'll talk about a few good things. I'm not going to spend a ton of time here because we don't have a lot of time, but I do want to remind everybody that right now we're still seeing green card backlogs in the EB2 category for everybody, regardless of where you were born. Our friends from India and China have longer backlogs than anybody else. And of course, from India, we have the longest, but everybody is seeing a backlog right now. And I think as of April 1, folks with priority dates earlier than June 22nd, 2023 are able to submit their adjustment of status applications. So, and have them approved, under that same category. So it is not just a little backlog, it's growing, it's persistent. I don't expect it to get much better. over the course of the next several years. The biggest question is, how far will it extend, right? Like, will it continue to grow, or will we continue to see a little bit of forward movement every year so that the backlog essentially stays about the same, over time? And we just, it's unclear to me right now what to expect. It's important to know, I've had a couple of questions about this over the last couple of weeks. When you look at the visa bulletin, if you've ever looked at it, you know that under the family section and under the employment-based section, there are two charts. There's a dates for filing chart and there's a final action chart. And what a lot of people don't realize is that the dates for filing chart does not apply every month that the visa bulletin comes out. The Department of State issues the visa bulletin each month, but it's USCIS that tells us which chart to use for filing adjustment of status applications. And that's, a function of their capacity at the time and what the current demand is, what their inventory is of cases. So usually around February, March, they start to say, well, you can only use the final action dates to file your adjustment of status application. And that's exactly what has happened. So right now, when I look at April, or even when I looked at March, if I have somebody whose priority date is in July, I can't file their adjustment application, even though the dates for filing chart makes it look like I can. I can only use the final action date to submit adjustment applications. And then, of course, that's the same chart that the government is using to determine which cases can be approved. So I just wanted to mention that because it has been something that's come up recently a few times. And I'm like, I know it says dates for filing, but you also have to check the USCIS website, and they're telling us we can't use it. So it's essentially like a vestigial organ there sitting on the visa bulletin. However, it is instructive because the dates in the dates for filing chart show us where the government thinks the category is going to get by the end of the fiscal year on September 30th. So it does kind of telegraph like where they think the visa bulletin is heading. So when people ask me like, look, how far do you think it's going to be? We might get to to August, whatever it is, by the end of September this year. We might get that far, in adjudications, but we just don't know. That's what the government's projection is, right? So that does give us some important intelligence on where things might go, but unfortunately, we can't use that chart for filing right now. All right. I have 3 bits of good news, just 3. The first thing is most employment-based immigration is still being handled normally by USCIS. I say most because we do have the suspension of benefits for the people who had the CHNV parole, the Afghan parole, Uniting for Ukraine, right? So there are some things that aren't being done normally, but my applications are still being approved. Like, cross my fingers, do all the whatever you do, like to ward off superstitions. Like, we all need to do it right now, but. I've been getting H-1B extensions approved in 5 days. My J-1 waivers are all going through with very little resistance. Things are moving. J-1 waivers are still readily available in a lot of programs. The federal programs, as of right now, are all functioning relatively normally. The waiver review division at the Department of State is functioning relatively normally. So there is some good news there. Are we a little bit like, do we have some anxiety about what might happen in the coming months? Yeah. Can I do anything about any of that right now? No. I don't know what changes might be coming. I don't know when, right? That's part of where the anxiety comes from. But right now, things are going well. The other thing we got back in January was this H-1B modernization rule became effective right on the eve of Inauguration Day. And it makes H-1B petitions a little bit easier for independent contractors. It makes some H-1B cap exemption rules a little bit more liberal. It does some other things that we don't love also, right? It was like a good and bad rule. But the good stuff in there is pretty good. And so I will take that as a positive news win kind of thing. We're still, testing the parameters of what's now available under that rule, but it's really promising. And I'm very much excited for some of the developments there. So those are our bits of positive news. And I'm going to go to the next slide, which has my contact info, but I want to cover the couple of questions that are in the Q&A. And if anybody has others, we have a few minutes to go through them. So let's see. So here's a couple of things on travel during a J-1 waiver. It's a great question. Um, so when you have a J1 waiver, when you have a J1 and you sign a contract and you're going to apply for a waiver, none of that impacts your ability to travel. The time when I don't like my J1 clients to travel is once the initial waiver agency makes a recommendation to grant the waiver. When your waiver is pending with the US Department of State, I get nervous about travel. Part of that is that if you're going to have to apply for a J1 visa stamp when you're abroad and you've got a waiver pending with the agency at the same time, it's reasonable to assume that the State Department might not want to give you that J1 visa if you already told them you're not going to comply with the home residence requirement, right? So that makes me skittish. Before that point, aside from all this other travel advice, travel is unaffected by your plans to get a J1 waiver. And applying for a J1 waiver is not per se evidence of immigrant intent that would keep you from getting the stamp. It's just that it's really hard when you're sitting there saying, yes, I agree to comply with 212E. And then, oh, by the way, yeah, you've got this waiver pending for me, right? Now, with the current political climate, you heard my advice. I think travel is really risky right now. If you're planning to travel closer to the fall into the summer, I'm not saying it'll be less risky then, but we may have a clearer picture. Some of this initial chaos may have subsided and we may get a better idea of what the new normal is. And so travel later in the year may be a little bit more reasonable than it is right now. And then let's see, I hope that answered your question. And then let's see. Yes. A person who's on a J1 may marry a US citizen. That is not a problem. I have plenty of clients who have. The one thing I will say is that if if you're on a J1, you can't apply for a green card, right? You're not eligible for a green card until you either get a waiver or comply with the waiver or you go home under the home residence requirement, right? So just your marriage to a US citizen is not evidence of immigrant intent. You guys could decide to go move abroad, right? I just met somebody this past week who married somebody from Ireland and they moved to Ireland. They didn't come here, right? So just being married to a US citizen does not prevent you from traveling in J1 status. And I think you go to the line that you are supposed to go to, right? So if you're on the J1, you go to the non-immigrant line, right? You don't go to the citizens line because you are not a citizen, even though you're married to a US citizen, right? Your status doesn't change until you actually might receive a green card or otherwise change your status. So just being married to a US citizen does not change your status in and of itself, if that makes sense. So let's see, I think I've got both of those questions answered. If anybody has any other questions, I am happy to answer them. We've got a good 5 minutes left. While we're giving you guys a couple minutes, I'll just say I have my contact information up here. You have my email address, our office phone number, and our website. You can go directly to our website and schedule a paid consultation with any of our attorneys directly there on the site. If you're not sure who to schedule with, maybe your questions aren't really up where my specific expertise lies. I mainly deal with physician and employment issues. So if you have a lot more questions about like TPS and things like that, maybe there's somebody else I would refer you into the office or refer you to in my office. And in that case, if you reach out to me and say, I really would like to schedule a consultation, but I'm not sure who to schedule with, that's great. And I'm happy to point you in the right direction. I would also mention there are 2 other attorneys in my office who regularly handle physician immigration. One is Adam Cohen and one is Megan Moody. So, if you look on my calendar and you're like, oh my gosh, I can't get an appointment for like 2 weeks or, 3 weeks, whatever it is, please schedule with Adam or Megan if they are available sooner. They are wonderful. Adam is a partner in our firm and also part of our healthcare group. And Megan has been with our firm for a number of years now. She's an associate attorney and she works exclusively with our healthcare group. So both of them are also fantastic resources for you. So there's a question here about whether working at a hospital means they will sponsor a green card application. And that's a good question. So every employer has their own policy about who they sponsor for anything, right? Are they going to do a J1 or an H1 for this particular position? Are they going to try to, do they have unlimited US citizens they can hire, right? When they hire people, Are they going to sponsor for green cards? Now, I will tell you that my employer clients typically will sponsor for green cards because they know that for the long term, it's in everybody's interest to go down that road. What differs amongst my clients is their policies in that regard. It's not an automatic thing. It's not automatic that you take a job and they automatically start a green card for you. Definitely a great question to ask a recruiter about what that facility, what that system's green card sponsorship policy is. Some of my clients have a 90-day waiting period. Some of them do it right away, but they're waiting for the doctor to ask because they want to know that it's required or requested. But none of my employer clients do it like as a matter of course, where we just go straight from H-1B petition directly into green card. So it's a great question to ask a recruiter. Um, but yes, most employers will sponsor. Um, Okay, well, these are good questions. How soon can your H4 spouse have an EAD, and can you expedite that process? So, wonderful question. An H4 spouse is eligible to apply for an H4 EAD when you, the H1B person, has an approved I-140 as part of some green card application process. H4 EADs can't really be expedited. However, I will tell you, even though USCIS is not formally bound by this policy anymore, if an H-1B and it is filed with premium processing and the H-4 and the EAD application are filed at the same time, in a lot of cases right now, USCIS is approving them all together. The fastest way to get your spouse eligible to apply for an EAD based on approved I-140 is by pursuing an I-140 based on a physician national interest waiver, which is based on working in an underserved area for 5 years. To me, that is absolutely the fastest way to get an approved I-140. Of course, there are a lot of important requirements in that process, and I would not just go tell you to knee-jerk go do that, right? There are a lot of considerations, but that would be the fastest way to do that. And a lot of times, if we do that if we go through the PNIW, we can do the J1 waiver at the same time, and then we go to H1B, H4 EAD, and everybody starts work around the same time, and it works out really well. It's a really nice strategy. USCIS says they don't see themselves as bound any longer to do the H1B, H4, and EAD at the same time. We're finding in most cases that they are, but yours could be one where they don't also. So that there's a little uncertainty there each time we file. So you have to be aware that it may, well, it's happening for a lot of folks. It's not happening for everybody. So just something to consider. Clarification of the prior travel would be safer if the J1 person comes back to the US before submitting the waiver. After submitting, it would be safer to not travel or get a new visa stamp until we switch to the waiver H-1B. You know what? That's a very conservative position. I would not disagree with that. The time when I really get nervous about travel travel on a J is, like I said, the second step of that J1 waiver process goes through the State Department. Before that, I have not had any clients have trouble traveling. Once we get to the State Department side of things, it makes me a little queasy. So, if you don't want to kind of think about all those details and you're like, look, I just want to be in the US for my whole waiver process and stay, you won't get any disagreement from me. But you don't have to be quite that conservative if you don't want to, or if there's an emergency or something that you need to travel for. All righty. Well, I think we have used our full hour of time, so I'm going to turn that back over to Rainey.
Awesome. Well, does anybody have any more questions before we finish? Wait a sec. I did want to remind everyone that this webinar was recorded, so within the next couple of days, I'll have that recording emailed to all of the registrants, and I will also have it posted on our website. Okay, I don't think that we're getting any more questions. Thanks for attending, everyone. Thanks, Lisa.